All right. A very good evening to everybody. I'm Tarun Khurana from Khurana and Khurana IP attorneys and from IIPRD. Welcome again for another round of our webinars that we've been doing for the last about 3 months or so now. And a lot of people, members that are attending are new members, not the ones who sort of attended our previous sessions, which are more technical and legal in nature. This one, for a change, focuses more on commercial and licensing related aspects of intellectual property, and therefore we thought it's an opportune time for us to have Nasir and John, who are partners at Blackhawk Technologies and are extremely professional, extremely competent in the areas of patent licensing and technology licensing, and I thank John and Nasir for joining in the round and taking time, coming in from the US. It's an early morning for you on a Friday. So thank you very much, Nasir. Thank you very much, John. Maybe we can start off with a quick introduction. I've already shared the screen, so everybody already can sort of see the presentation that we're going to look at. And maybe Nasir, you can start off with a quick background and introduction, and then we can take the presentation along on the lines that we spoke about from an agenda standpoint.
All right, very good. So thank you, Tarun, and thank you everyone for joining. I want to first acknowledge K&K. I worked with a lot of law firms, and the professionalism of Tarun, Arindam, Bhumika is just unbelievable. It's been a pleasure working with you guys. Next slide. Yeah. So before we go into introductions, I wanted to tee up this webinar. Tarun had suggested some topics that we should cover, and these are the topics that we will cover, and we will talk about each in their own section. I believe that Tarun will be emailing this presentation at a later date, so there's no need for screenshots, or if you want to take notes, you can concentrate on that.
Sure.
The information we'll present is based on our experiences, and your experiences may be different. We would love to hear from you because we always want to learn. Next slide. All right, so we will start with introductions individually and also of the firm. My name is Nasir Luqmani, and I'm the Senior Managing Director at Blackhawk Technologies. After my education, I started my career in GE and then in Bosch. In early 1990s, I started a design and engineering company. My customers were Lear Corporation, United Technologies, TRW, Ford, Bosch, and others. In late 1990s, I purchased a plastic injection molding company. I had 3 locations, 40 machines, from 50 ton to 1,000 ton. We were making parts from the Ford Mustang shift knobs all the way up to bumpers for GM. My customers there were Eaton Corporation, United Technologies, Ford, Lear, GM, and others. In mid-2000s, I sold the manufacturing company and joined Delphi. I was monetizing their IP in non-automotive space. Did that for about 10 years, and then I joined with John in Blackhawk, and that's what we've been doing ever since. So next slide, and I'll request John to give his introduction.
Thank you, Nasir. My name is John Cianamea, and I spent most of my career in early stage venture capital. I have been the senior person in 4 different venture capital funds and have run them the full cycle. Through these funds, I have invested in over 100 early stage technology companies. About 1/3 of them were in the life science area, 1/3 in semiconductors, materials, and electronics, and 1/3 in energy, software, optics, and all the other areas. Through the venture investing, I became involved in licensing, first inbound to portfolio companies from universities and other sources, and then outbound to others, and then asset sales as a means of exiting investments. I began working full-time doing mergers and acquisitions and IP monetization in 2008. I also live in Raleigh, North Carolina. Next slide, please. Blackhawk is a mergers and acquisitions advisory services and IP monetization firm, and we serve companies globally. Very simply, we help companies sell assets or license intellectual property. We generally represent the seller or licensor. We split up our services into three main areas. In the areas of mergers and acquisitions, divestiture of assets is a big part of our business. We help companies sell products, technologies, product lines, or entire businesses. In IP monetization, we help clients divest intellectual property. And intellectual property, you'll see in some examples, is often more than just the patents or applications. We also, from time to time, are asked by clients to help find patents to acquire. And we have some proprietary processes where we can very efficiently and quickly identify patents that meet the criteria, qualify it, reach out to the owner, sign them up, and present it to the interested party. The last area of service is strategic advisory. We generally help some clients with financing issues. As an example, we recently helped secure funding for a client who had very large orders related to production of hand sanitizer. We also, from time to time, help some companies with equity raises. We work with a number of firms. We have a German partner called Florentis. They're gentlemen like us who have worked in industry and have very good connections. We also, for years, have been working with Richardson Oliver Law Group, among others. You'll find in our examples that we have very broad experience, and we have done deals in most technology areas, including medical devices, healthcare, software, electronics, biotech, oil and gas, textiles, and so forth. Next page, please. We'd like to have a discussion, next page, about how has licensing changed, and maybe begin by looking at where is the current state of licensing. And let me explain the three charts on this page and then give a few comments. The graph on the left is the average price per asset by package size. If you look at it, generally the 2019 asking prices by package size is up over the 2018 level. And a package size means that if you were selling, excuse me, a portfolio of patents and applications, you may have 5, you may have 10, but that is, excuse me, that is the package size. It's also interesting, if you look at the left side of that graph, the package size of 1 in 2019, the ask is up almost 3 times over the 2018 level. And I should also point, that is an ask. It doesn't mean you necessarily get that price. The table on the top right is the asking prices in the 2019 market. You'll see that the average ask per US issued patent was $280,000 US. The average per asset, which would include applications and issued patents, was $194,000 US. The histogram on the bottom right is the distribution of package sizes, which are the total assets being offered. You can see the majority of the packages are under 5 assets. And I think it's safe to say the majority of the packages that we deal with in Blackhawk are under 20 in size, although we have had portfolios as large as 1,000 assets. It is interesting to look at how the ask has changed over time. In 2014, the average ask was $360,000. This was the last big year of buying by Intellectual Ventures, which was an aggregator of patents. It trended downward. In 2018, it hit 176,000, which was the bottom, and then rebounded to the current 2019 level of 280,000 US dollars. If you look at the number of packages being offered or shopped for sale, it was 566 in 2014, hit a high of 772 in 2016, and then dropped back down to the level of 448 in 2019. The bottom line is there's a lot of intellectual property packages being offered. Next slide, please. The graph on the left is the cumulative sum of asking prices in the brokered and tracked private market. And you can see roughly 1/3 is being sold. The histogram on the top right is the distribution of seller type by sale year. 60% of the sellers are operating companies in 2019. In 2014, it was 62%. The inventors selling was roughly 10% in 2018-19. 2014, it was 21%. On the bottom right, the histogram is a distribution of buyer type by sale year. 40% were operating companies in the current report. In 2014, it was 46%, so no real change there. Non-practicing entities, which are companies that acquire patents generally to assert, was roughly 50% in this report. In 2014, it was 38%. I'm not showing the timing here, but for 2018 offerings, 30% sold within 6 months, 80% sold within 10 months. In 2015, 55% sold within 12 months. We generally tell clients the average is 9 months. So if somebody gave us a new portfolio today and said, go, we tell them, expect it's going to take 9 months until you see a check. Now, we have sold things quickly in a matter of weeks. We have also stuck with opportunities that took over 1 year, but 9 months is about average, and it's consistent with the numbers that I was just reporting. Next slide. In terms of how have licensing changed, years ago, and I've been doing this for a long time, it was a lot easier to get someone's attention and have a discussion about licensing or investing. And the internet changed a lot of things. In particular, it made it easier to submit offerings. And we have a number of buyers that tell us they just are buried with unsolicited offers to buy patents. The buyers don't have time to look at everything, and the challenge is, how do you make your portfolio stand out? And I think we're going to show you some examples about how you can do that. There were also several events that changed the market. In 2011 in the United States, there was what was called the American Invents Act, and that made it easier to challenge patents and invalidates patents. There have also been some Supreme Court cases in the United States. In particular, they're referred to as Bilski and Alice. They also made it more difficult to sell methods patents or business-related patents. In the end, I really believe that you need relationships and a process to make your offering stand out. Nasser, do you want to add anything to that?
No, I think that was good.
Next slide, please.
Okay, so I'll take this. There are 6 basic types of M&A transactions. And they're not just in individual buckets. It could be a combination of a few of them. So number one, starting from the top, is to just sell the company. We work with a number of companies that just want to sell lock, stock, and barrel. We are also connected with a couple of trustees to help them sell assets which are under bankruptcy protection. Number two, wind down of products. Many companies decide that they no longer want to produce a product. A better alternative to mothballing it is to license the technology including the drawings, test data, designs, patents, equipment, know-how, etc., to get more value. Number 3, legacy products. These are products a company used to produce or is producing in low volume for service that they would rather get out of their facility to open up space for new production. Number 4, patents for sale or enforcement. Many companies are looking to reduce cost, and they want to sell their non-core patents to reduce their IP maintenance costs. These patents can either be sold or enforced if they are infringed to generate revenue. And we work on both sides in that area. In all of these transactions, the IP owner retains all usage rights for their own products. Number 5, license in new or adjacent markets. A good example of this is an automotive company licensing their radar technology in the mining industry. It protects the IP owner's primary market and yet leverages the technology to generate revenue in markets they were not planning to participate in. And lastly, number 6, license core products in niche markets. An example of this would be a US company leveraging their technology in Russia, for example, where they would never put in a facility or start producing product to supply locally. Next slide, please. So this is an attempt to represent what we see in the market. And it requires some discussion, although I'll touch on it at a 10,000-foot view, and you can always ask questions later. A patent portfolio, for example, can be monetized in 3 different ways. Number 1, through enforcement, which is the left column. Number 2, using the IP to initiate a startup, which is the middle column. And number 3, an outright sale, which is the column on the right. Now, again, they're not individual buckets. They could be a combination of processes. So for example, a portfolio can start off as an enforcement campaign and quickly turn into an outright sale because we were successful in showing the buyer the value of acquiring it rather than letting their competitors have it. Now on this chart, we are showing 3 curves. The blue line represents risk of either invalidity or of revenue. The green line represents the IP revenue potential, and the orange represents the time it could take to realize revenue. So let's talk about column 1, enforcement. Infringement inherently implies that the technology is already in the market. In that case, a startup would not make sense because you're not offering something new in the market. Enforcement can also result in higher revenue compared to outright sale, which is shown in green. However, it is also riskier, shown in blue, due to a number of reasons, such as validity challenges, counter lawsuits, etc. A good option for infringed patents that we employ is to make the target aware without threatening them, so there are no counter lawsuits or defending actions taken by the target, and then outright selling the portfolio to them. And we've done that successfully in a number of occasions. So let's talk about column 2, startup and licensing. When the IP is disruptive, this is the better option. There is no infringement because it's disruptive IP, and an outright sale will likely not yield the real value of the IP. The best alternative in this case is to license the technology to a strategic and ride the commercialization partner for ongoing revenue. In column 3, which is outright sale, an outright sale is simpler, it's quicker, but it is important to do your homework to find that right buyer who truly values your IP. And we will talk about, as John had mentioned, we'll talk about process a little bit later as to how we do that. Next slide, please. Are we on the next? Okay, there we go. So technology valuation. A question we are routinely asked by especially individual inventors is, what's my technology worth? In our experience, the real value of IP is actually very different than what a buyer may be willing to pay. There are a number of factors that affect the value of the technology, which is separate from the price that it may generate in the market. And here we've listed 6 parameters just as examples, 3 for the buyer and 3 that are seller specific. So for example, first question is the technology strategic for that specific buyer? And if so, how important is it on that scale? So suppose the buyer determines, I must have it. It's something I need, it's good for my business. The next question is, does the buyer have the resources to pay for it based on what the seller is asking for? So there's interaction here. It's not just putting it in the market and having the money to pay for it. Even if the buyer has the resources, can the buyer justify the purchase price? In other words, what does it do for him? Does it open up a revenue stream that would justify this purchase? On the seller side, the 3 parameters are, what is the seller expectations? We've had inventors who have had 1 patent and they want $1 billion for it, which is obviously not going to happen. Then what space is the technology in? Is it in mechanical switches or is it in Internet of Things? So the technology space is very important. Where are the hot spaces that companies are buying? And then another example is, what's the quality of the IP? And that is a whole separate subject with respect to, and it has nothing to do even with the IP. It has to do with the quality of the patent and the claims and the payments and the chain of ownership. And so it's a whole separate discussion on that. So in essence, there are many variables, and to try to find that buyer that has the indicator at 100% for all parameters or most parameters is what we do with our process with John, which John will cover a little bit later. And that is why we've been fairly successful in our transactions. One example of this that I've given in the past that I'd like to give is this Seiko watch. Okay? My sister bought this watch for me 50 years ago. Okay? It's not expensive, but to me, it has a lot of value. In the early 2000s, the spring on this watch broke, and Seiko said they couldn't fix it. I couldn't find it anywhere. In 2004, I was walking the back alley visiting some shops in Pakistan, and I found that spring. I was willing to pay whatever the shopkeeper wanted for that spring. Now, I bought that spring for 1/100th of a penny. And the reason was that the shopkeeper didn't know how important that spring was to me. So we have adopted that philosophy at Blackhawk. We spend a lot of time upfront building a value proposition, researching the IP, and finding the right buyer with all of the parameters in green to generate the most revenue for our client. We never shotgun the process. We don't send out hundreds of emails in the hopes that someone will respond. All that does, it reduces the value of the IP, and it telegraphs to the world what our clients' business strategies are. Next slide, please.
Oftentimes, we are asked by a lot of clients, what is my intellectual property worth? And there are some methodologies in terms of estimating the value of intellectual property. It's like selling a house. If you're selling a house, you often want an appraisal just to make sure you know the value and you're not going to leave money on the table. The easiest way to check out a valuation is to look for comparables in the marketplace. We have several databases we use, as well as our own database of past transactions. But periodically, we do recommend to a client that a valuation model be prepared. An evaluation model is a large spreadsheet with multiple tabs that allows for adjusting variables to test assumptions. There are variables related to the risk associated with the intellectual property, such as the obsolescence, the ability to invent around, and so forth. Market share for the technology or product, the cost of capital, and other assumptions. Cases where we might suggest a valuation model be appropriate might include a very large or potentially high value portfolio. Again, you want to have confidence that you are not leaving money on the table when you get into negotiation. It's also helpful in instances where you have multiple sectors in large growing markets, and you may be looking to do field of use licenses. You need to understand the value of each of those sectors so that when you approach the licensee, you can have an appropriate ask. It's also been our experience that many buyers don't have a real methodology in terms of assessing the value of intellectual property. A lot of them just based it upon a recent transaction. If they paid $50,000 per asset in the last transaction, that's all they should pay in the next one. So you need some ammunition to help them change their viewpoint. I'll give you two examples of where we did valuation models for clients. And the first example was a semiconductor client that was planning to sell its intellectual property as part of the winding down process. The intellectual property addressed large growing markets. It was best in class in terms of the semiconductor devices. So the question was, what is it worth? The key companies that were playing in the space, selling products in the space, were identified. And then we developed a model to demonstrate how the licensee would benefit and what it would cost them to get into the business. In this case, we actually shared the model with one potential buyer because they were stuck on that old method while I paid $50,000 per asset in the old case. In the second example, we had a telemedicine client. They were an early pioneer in the field of telemedicine. They had very good early intellectual property. It was started by venture investors, and the company was going out to raise a significant equity round. The company had a big difference between their ask and what the venture investors or the new equity players were willing to bid. They wanted a third-party valuation to help close that gap. In the end, it did bring the gap a lot closer with the valuation to show the potential investor what the value of the intellectual property was. Next slide, please. We have a 9-step process which is agnostic and can be applied to any type of portfolio being sold. Now, we don't do necessarily every step for every portfolio, and depends upon the complexity of the offering. But it all begins with an inventory and assessment of the assets. We want to understand what is owned, what is the condition, what is the status, and what can be added to the package. We often find that companies don't think of know-how, the design specifications and other what I'll call soft assets as being important, but it will add value to the package. So we help extract that information and inventory it so we have a complete package. In the second step, we often build a data room if there is a large amount of information. And the data room is an online repository of information. It is permission-based access, and there may be 3 or more levels of access based upon the interest of the potential buyer or licensee. We prepare documents to go to market. It generally includes a teaser, which is anywhere from 2 to 4 pages. This is non-confidential information that we use to begin the discussion with the interested party. We also prepare generally a PowerPoint document, which is used to guide the first discussion involving the seller and the buyer. Next step, we identify, and a lot of these steps go on simultaneously. We identify similar transactions. We have access to several databases. We look for comparables in the space, and the comparables are sought to see what pricing has occurred in recent transactions, but also who is buying or who is selling. And this helps in identifying the strategic targets. We also have access to several databases of market research reports so we can see who are the players and where the market is going. We assess and map the importance of the IP to those targets, and it gets back to Nasser's point with the example of the watch and the spring. In the end, we take that list of targets and we prioritize it into an ABC priority list and review that with the client. We develop value propositions for each of the targets, and in some cases, we will modify the teaser and the PowerPoint for that particular target. Last 2 steps, we engage and negotiate terms and close out a win-win transaction. Next slide, please. There are a number of reasons why people want to sell intellectual property or license intellectual property, and we're going to give 4 types of examples. The first has to do with gaining value from an asset that is no longer core to the business. And I think this is a somewhat recent trend in that in the past, I think when a lot of companies discontinued a technology or a product development, they just forgot about it, wrote it off. Now there's more interest in how can we recoup some value from that asset. We also have seen where in certain early stage companies or emerging companies, they would like to license intellectual property as a way of raising capital without dilution to its shareholders. And third type of a transaction is to seek a commercialization partner. Many early stage or emerging companies do not have the brand, the resources, or the distribution channels to be able to adequately address a market. And the last is a liquidation of business assets. Excuse me. Next slide, please. Volvo Car Corporation is a client for Blackhawk. Excuse me. In 2017, Volvo made a strategic decision to move to fully electric and electric hybrid vehicles. They had several research programs underway, one of which was regarding a hydraulic pump motor that was going to be used in a vehicle. If you know about hydraulic pumps and motors, that technology has been stagnant with no real innovation in the last 50 years. The research program actually made a significant advancement in the technology, and it has broad application beyond automobiles. Hydraulics are used in off-road construction equipment, airplanes, and on and on. It is a very big global market. We were engaged to find a buyer for the technology. We did the process that I described earlier. First, what were the assets that were available? You have technology, you have drawings, you have specifications, you have prototype. There's a lot of information related to the particular device. We also had to find who were the key people, excuse me. In order to sell, excuse me, an asset in a case like this, you need to actually be able to help with the technology transfer. So who are the key engineers that could help, and are they available? Next is to develop a probable ask. And working with the client, you develop a parameters about what is the ask. We prepared the pitch documents, the teaser and the pitch deck, and then we engaged with multiple parties that were identified through market research reports and looking at similar transactions. As part of this, we also coach the client team. We just don't let them speak to clients outright, but we want to make sure that everybody understands the role in the meetings and how to move a transaction forward. So we organize and chair meetings between client and the potential buyers or licensees, did the follow-up with different clients, coordinated the hands-on testing, developed offers, and ultimately concluded with a transaction sale. Next slide, please. Silicon Semiconductor Corporation was a venture-backed company, and this is an example of raising capital with non-dilutive funding. The company had raised about $10 million for product development, had best-in-class technology for what it was doing, and was not getting traction in the marketplace. There were a number of things going on in the marketplace. When I say traction, in terms of corporate partners or getting into certain product channels. The company needed to raise some additional capital, but did not want to give up what the buyers wanted to pay for. So the idea was, why not license the technology to one or more parties? The company's technology was addressing a number of different sectors. Some were more core than others to silicon semiconductor. So in the end, a licensing package was prepared, targets were identified, they were engaged in terms of discussions, and in the end, a license was achieved, which was $5 million non-dilutive funding. This was a prepaid one-time license for a specific field of use, and the specific field of use had parameters in terms of applications. So again, an example of using, next slide.
Okay, so this is a good example where a client was seeking a commercialization partner. Kerdea Technologies invested 8 years to develop a resistor-based oxygen sensor. Everything else out there is zirconia-based, which is expensive. It has issues with durability, and its response time is not as fast. So this sensor is the smallest in the market. It's got the lowest cost, and it's fastest. And it's akin to being able to use a bucket in a boat where you can empty out the water that it's taking quicker, and that allows you to reduce some of the other things like the catalytic converter, etc. Every combustion engine out there uses at least one of these, and in many cases, 2 of these. So 2-wheelers, 3-wheelers, 4-wheelers, lawn equipment, mining equipment, Zambonis, generators, etc. So it opens up a number of different verticals for the commercialization partner. We were able to successfully license this technology in India to a strategic tier 1. It was a couple of years ago, and that's where it's at right now. All right, next slide, please. This is another example of a client that we are working with right now. to find a commercialization partner. Their product is called Footbeat. It is proven to increase blood circulation in the lower extremities. The current systems out there are the contraption around your legs and pulsate it to increase blood flow. Blood circulation is critical in many medical conditions, including diabetes. And we know that diabetes is on the rise. We also know that us Asians love our sweets. So the laddus, the jalebis, the pedas, and this product can really benefit in those markets. There was a recent situation where a 70-year-old male was scheduled for a leg amputation in Colorado Springs. So as they scheduled his surgery, his amputation, he was given one of these units to try out to increase blood circulation in his legs. When he came back for pre-surgery consultation, he was told by the doctors that his condition had actually improved significantly and that they wanted to wait and see whether an amputation is required. Now think about that. We are working with a number of large healthcare providers who want to add this product to their product offering. But these providers don't necessarily want to produce the product. And therefore, we are seeking a commercialization partner to license this technology and take it to production. Next slide, please. This is another example. This is an example of assets pulled out of bankruptcy. OpenPeak was an AT&T initiative. It was a spin-out, and they spent about $200 million developing software for tablets. And in fact, some of AT&T products actually had this product in them. And there's a lot of information on YouTube. So if you search OpenPeak, you'll see the history. They filed bankruptcy, and our client purchased the patent portfolio out of bankruptcy. It had 4 different verticals with over 100 patents. The patents had significant infringement, and we were able to leverage that infringement to outright sell the portfolio to a large phone manufacturer. Next slide, please. So this is another example of valuable technology where we are looking for a commercialization partner. About 50% of all ICU antibiotics are used for infections due to trapped secretions during intubation. Intubation is where they put a tube in because you don't have the ability to breathe. This technology allows the secretions to be expelled through a separate path rather than stay trapped in the lungs and cause an infection. The technology has been tested extensively in pigs, and our client is looking for a commercialization partner to take it to production. Next slide, please. So,
well, we're getting close to the end now, but in terms of tips for success, I think through our experience, we have several ideas that will improve your odds and your yield from your portfolio. First, you identify Aaron and his team. They probably can help with those processes, but we know of a lot of companies where they don't take the time to protect the IP because somebody may not think it's important or patentable. They don't understand the value of know-how and really protecting the trade secrets. But it's very important to do that, do it early and regularly. Next, you should search and review your products or your technology periodically to see if things are no longer core. If they're not core, you can save some money by selling the asset, and you don't have to pay for the patent maintenance fees. But why not gain some value from things that are no longer core? Many businesses shift over time to new markets, new strategies, and are always adding new products or dropping products. The third point, consider selling or licensing legacy or low volume products to open up floor space. A lot of times companies have to reserve floor space to manufacture products to support a product that was dominant years back. You could out-license that production to some other company. They could do it for you, and you can then free up your space and personnel to do other things that are more profitable. The last point is to divest and wind down products and patents and inventory. As in the example of Volvo, if you have things that are no longer core, General Electric was a client where they had certain technologies that were developed, for example, in the oil and gas space. The products were more downstream or at the retail level and not core to the business, also minor in terms of the size of the overall business. So again, there are opportunities where you can monetize things that no longer fit or add enough value to your business. Nasser, would you like to add a few points?
Yes, I'll make some general comments, and some of them will overlap what John just said. What I have found in my decades of corporate experience is that engineers are an amazing bunch. The quality and amount of IP locked up in their minds and their desk drawers is unbelievable. I've had situations where engineers have reached into their desk drawers and pulled out complete designs of products which never made it to production because they were not strategic to the company. Look for those opportunities. There is a gold mine locked up in every engineer's desk. Secondly, whenever you're thinking of divesting IP, think broader than just patents. Think about the design, the drawings, the test data, know-how, prototypes, equipment, and even engineering notebooks. When a client reaches out to us, the first question we ask them is there a product behind the IP? More often than not, those patents were generated because there was a product or a thought of a product or prototypes behind it. And when you lump those in the IP offering, the price you can get in the market is much higher. Next slide, please. Thank you very much. Tarun, you want to take over? This is a backup slide that we don't necessarily need to talk about and is redundant with some of the other stuff we've presented.
Excellent. Excellent, excellent, excellent. Thank you. Thank you very, very much, Nasir. Thank you very much, John. It was a pleasure and very well covered. We are fully in time for a few questions that we can sort of take up and deliberate upon. But just to start with, you did refer, John, to a few databases that you guys refer down to when you're doing a comparable valuation study based on comparables. Are there some public databases that you could perhaps share names of that sort of store comparables and probably can be licensed, subscribed to?
The ones we use are fee-based databases, and I know you can pay a lot. The one that's probably most expensive is PitchBook, which is very complete. Merger.com is relatively inexpensive, but is still very good. And MarketLine, I don't remember the pricing, is also decent, but PitchBook is probably the most expensive of the three.
Also,
And I'm not aware of any free databases. Now, there are from time to time publications if you're on certain email lists where you can sort of gather things up. The other thing you can do, though, is if you know certain buyers are public companies, oftentimes in the notes to the financial statements, they will list their recent transactions, and they will list their recent transactions in terms of licenses or acquisitions.
another point is that we stay connected with our targets, and not just when we need something, but also when they may need something. So we routinely ask what they are looking for, what are they interested in, and we have our own proprietary Act-based database where we record what certain clients are looking for. And so when a client brings their technology, that's the first place we look as to who in our database was looking for that technology.
Sure, perfect. Aradhana asks a question. I'm just taking for the moment questions from the chat box. There's a question that asks about the problems that the licensors or the sellers would usually encounter while licensing their technologies. What are the typical problems that you think are the most common, and perhaps if you could highlight that or talk about it for a minute?
John, you want me to take it?
Sure.
So I think that managing expectations is one. And IP owners always believe their technology is the best in the world. The fact is that there are many alternatives. And so you have to look at it from the licensee's point of view of, you go to a Best Buy and you see 10 different televisions. Okay. You find the television that best suits your needs at home and your price point. So it is an art to manage the licensee by showing them the value of the technology, but then also bigger than that, managing the licensor of what realistic value they should expect and come up with a solution that works for both. One of the things that we do is in all of the licensing, the elements are there's a reasonable upfront amount of money, because you have to come with your marbles to play. And then second is to ride the wave. So if the licensee becomes successful, the licensor should become successful. It should be a reasonable % on every product that is sold out there. Another element is the licensee may not be expert in that technology. So bringing in the element of the expertise with a consulting agreement where the licensor can help the licensee go to production and generate revenue because it's in both of their interest.
Sure. There's another question from Prem, which I think I concur with quite a bit. And then summary says that a lot of times individual inventors and even small entities, whenever they do try to license out technologies, the licensees or the buyers do intend to ask for working models and to ask for the prototype or some proof of concept, and just the IP per se is usually, or in most cases, not enough. How do you handle those scenarios in the US, and is there a way around that requirement?
John, you want to take it?
Yeah, I'll start with that. We generally classify the offering using a technology readiness level. This is something that was developed either for NASA or the military in the United States. So a technology readiness level, for example, of 9, I think that's the highest, means it's commercial one is conceptual on paper, and we're upfront in terms of disclosing what is the technology readiness level. We also, when we're presenting it, if the prototype, we've had breadboard prototypes with wires hanging off and just looking like a true prototype made in a garage. But the buyers understand that. They just sometimes want to see that it's put into practice and are willing to pick up on that. I think in the life science area, the challenge there is a little different because a lot of times, particularly in the pharma area, you need to have human trials. And a lot of people aren't interested until you get to that point. But if you have knocked out the toxicity test or some other early test, wash out some of that risk, you can still get discussions going.
And also, if there are no prototypes, so knowing what the IP offering is results in which customers or which potential targets you go after. So if there is IP and the target has no experience in that product area, then that's generally not a good target. So in that case, we would go after targets that have extensive experience in that area and can understand the value this technology can bring to their existing product.
Sure. There's another question from Kumutha, and we'll open up the forum in a couple of questions for people to ask verbally as well. How do you approach, for example, we're working on 3 or 4 projects together, Nasir, at this moment as well, where we are trying to find out buyers for the Indian market in that context, and not in all the cases does the IP get protected in India, right? And we are trying to sell US IP or maybe technology as a whole from a know-how standpoint. So how do you usually have scenarios where, for example, John talked about a European partner, and I'm sure not all the patents that you guys transact in Europe actually have a European family. So that was another question that Kumutha had asked about trying to do a transaction in a country where there's no IP, but it is in another country.
Yeah, I'll go first. The know-how is a big part, and it does enable someone to practice the technology. As an example, with a textile client we have U.S. patents. A big part of the market obviously is the U.S., but more importantly, we are enabling the licensee to be able to produce the textile with this technology. The know-how also outlives the patent, so that if you are doing a license, you're not limited to the term of the patent. But when we generally do the license, it includes right to the U.S. patents for that field of use, as well as the know-how for that field of use. So again, it is important, I think, to not diminish the importance of the know-how. You are enabling them and you're teaching them how to produce. Nasser, you want to add?
Yeah, and secondly, the fact that NPEs are thriving tells you that just because you have patents doesn't mean companies won't copy your technology. So that brings in the important question of what is the secret sauce that you don't have to share that will help the licensee succeed or fail, and that becomes very important. So that hits the point. Patents are infringed all day long in the US and all over. Some countries, you can go after the infringers, in others not. So you have to find creative ways of protecting yourself. Now, in the case of Kerdea, the example we gave, their sensor element is their secret sauce. It is not in any patent. They have 17 or 20 patents, but that secret sauce is still secret. So even if somebody wants to copy their sensor wherever in this world, they won't be able to because they don't have that secret sauce.
Sure. Ashutosh has another question which talks about negotiating deals. A lot of times individual inventors are on one side and they're probably not as equipped and not have as much of bargaining power in terms of trying to demand a high upfront and perhaps a decent royalty of 4 to 5%. So what according to you has been some of the best practices during negotiations at the time of maybe preparing the term sheet, so that even a party which is the licensor, which may be a small entity at that point in time, gets some leverage to sort of get a good deal out of the whole process?
Yeah, I'll take that, John. So negotiating is an art. Okay. I apologize for saying this, but lawyers don't make good negotiators. They're excellent at what they do, but business people can negotiate because they can put themselves in the other person's shoes. That's why when you go to a dealership, you always have a sales guy in between the consumer and the financier. And I can guarantee you, this sales guy in there is actually telling him what we're going to offer this guy. But if you, so people like us, to separate the seller and the purchaser is the best thing you can do, because you're not put, so if somebody says, hey, I'm only going to pay $500,000 for this, you don't have to say, well, the hell with you, I'm taking my product somewhere else. You say, well, let me find out from my client. So I can divert that from a stronger negotiation at that spot, and then come back and say, hey, here are the reasons why it should be $1 million. And we'd like you to consider this because of these reasons. So it allows us to come back prepared to answer that question. So whenever you're negotiating, you should always, whether it's your wife or anybody else, put somebody in between you and the buyer rather than doing it directly. John, you want to?
No, that was good.
Okay.
So Amit, you've asked a question on secret source versus enablement requirement. Perhaps a question better answered by patent attorneys, because they'll be able to tell you a balance between drafting an application so as to sufficiently explain but still sort of maintain certain trade secrets there. So we can perhaps take that in another session. So any other questions anybody wants to ask verbally in that sense? Anybody at all for the next few minutes?
Yeah, I got one question. Hello.
Yes, go ahead.
My question is, in WIPO, when somebody puts up an application in WIPO PCT application, there's a provision if somebody wants to keep this application for licensing. They have this kind of provision. What's the success rate of licensing from this platform?
We have not experienced. Are you saying did you say WIPO? WIPO?
Basically,
yeah, PCT application. Because when somebody puts in PCT application at WIPO, they do have a provision wherein somebody can indicate, yes, I want to license my application, and they keep it on record there at WIPO website.
So if I understand your question correctly, to get a licensee interested, you have to show them the path to riches. Okay, what's the road to the pot of gold? And an application by itself doesn't do it. What you have to show is how your technology can benefit their existing products, and not 20 years from now. The rate of the return is anticipated within 2 to 4 years. So, and that goes back to the question of, if you just have a concept and don't have prototypes to show for it, there's a long development path that is going to tell the licensee, potential licensee, that, hey, I can't think that far in the future. So the probability of success is low. The best way to position your IP for licensing is build a prototype, do some initial testing, whether it's a breadboard or in your garage, do some testing, put some value around the concept, and then take it out to a licensee. Hey, this is what it does. I've tested it. Here's a prototype. I can prove that this works.
Yeah, I've got another question. For any patent to be licensed out, what my understanding is, one has to arrive at net physical value. What are the factors which are considered to arrive at that net physical value, which in fact determines the cost of the patent?
That's a difficult question to answer, because you have to then engage with somebody who knows the market. For example, if somebody comes up with an awesome mechanical switch, for example, a trunk latch, it may be the quietest, it may be, you may be able to close the lid with one finger, but it's not an area that's going to generate a lot of interest in the market. So if a technology generates a lot of interest in the market, it enables companies to generate revenue, it enables them to differentiate themselves from competitors, that becomes valuable. If it doesn't do all of that, then it's not going to be valuable.
Thank you.
Sure.
Any other question? Just perhaps wait for just 1 minute, Nasir, and see if there's any follow-up question. Meanwhile, we sort of, just the last question from my side at least, was around the fact that a lot of times when we try and reach out to companies with propositions or technology licensing, follow-ups on that doesn't really help you that much, because once you know that a company has had a look at it, as a licensing professional, can you really change the mind of a licensor or licensee, or a potential licensee rather, once he's made up his mind that he's not interested? As a licensing professional, have you encountered scenarios where you've been able to really change the mind from a no to a yes? And is that common? Because I think those people are subject matter experts. They can have a very quick look at it and probably in 10 minutes can tell whether or not they'll be interested in it. So I was sort of just I was always curious from that perspective.
Yeah, no, that's an excellent question. And in fact, John and I have a lot of discussions on how often do you reach out to them again. My philosophy is, if somebody says, hey, I can do all these patent analysis for you, and so I have a decision, I can say, I'm not interested. And now we've started a dialogue and you say, well, wait a minute, I can do this for you. And I don't want to start that. So I generally, and I'm telling a lot of people this on here, I generally don't respond if I'm not interested. Okay. Now, if I get bombarded 2 or 3 more times with emails, I block them. I don't want to hear. You're absolutely right. That is an excellent point of how often do you go back and say, hey, I sent this to you, you didn't respond. Well, that should tell me something that they didn't respond, right? But on the other side, sometimes what happens is, hey, I didn't see this. It ended up in my spam. Thank you for reaching out, right? So generally what we do is when we have very specific targets, we build a relationship so that there's communication, a lot more than just, hey, every time I have something to show, it's communication, they get to know us. We try to build a relationship wherever we can. Just like you, Tarun, you reached out to us and say, hey, we are here. And I say, hey, maybe we can do some work together and mutually benefit. So, and so what we do is, one, build a relationship. And number 2, we find 4 or 5 entry points into that company. So even if one goes into spam, we just had one recently for Volvo, where a gentleman reached out and said, hey, you sent this to this guy. I didn't get it. I'm very interested. So that's how we address some of those. Now, John, I think, is a proponent of following up 2 or 3 times, and I'll let John defend his position.
Sure.
I tend to pester people until they tell me to go away. But I think it's also important on who you target.
Well, I fully understand. Fantastic. Thank you very, very much for the insights again, both of you. One final question from anybody in the participants. I think we're good to go. Nasir, it was such a pleasure. John, was an indeed pleasure. It's an early morning for you. Excellent. Thank you very, very much. We've recorded the session, so we will be sharing the link of the YouTube where we'll be uploading this as well. So look forward to perhaps doing another one in the next couple of months or so on another more specific aspect. But thank you very much. In the meanwhile, thank you very much everybody for attending it, and we look forward to doing and continuing to do these webinars in time to come. Thank you very much.
Thank you very much, Tarun.
Pleasure. Thank you.
Thank you.
John.
Thank you very much. It was lovely indeed.
Thank you.
Thank you.